Hello, my fellow public servants. This video today is about the grievance process. And so, how the grievance process works, we, from a date of an event, something happens, we have 30 days to file a grievance according to the CBA, according to the contract. So, what can we file a grievance over? Just all sorts of things, just about anything. But specifically, what we file over are violations of the CBA, the collective bargaining agreement, and then violations of law. And what this video is mostly dealing with is violations of EEO law. So that's absolutely something we can file grievances on. And one of the reasons we like to do that is after we file the grievance, generally for things that are decided at the director's office level, is what's considered a step 3 grievance. They go steps 1, 2, 3. It's the highest one. And then after a response or even non-response, the contract lays out the procedure. Then we can move that to arbitration if we don't get it resolved. Hopefully we do get it resolved. That's why we're filing it. That's the whole point. But if we don't have to get it resolved for it to be useful. We can still then move it to arbitration. And that is an arbitrator that will review the contract, review the law, review the set of circumstances that we've laid out, and then make a decision on whether or not policy procedure was followed, whether or not the contract was broken. And we can ask for remedies as a part of that grievance. So one of the reasons we really like it is those can be done in 3 to 4 months. Maybe 6 months at the outside. So much faster through this grievance process versus maybe 3 to 4 years in the EEO process. And we can use the same laws as are in the EEO process, in the grievance process. There are some weaknesses, some concerns about, one of them is discovery. So in the EEO process, we get something called discovery, which is where attorneys or whomever can subpoena documents and records from the agency. So we like that because it forces them to give it to us. We don't have that in the grievance process. But there is another portion that we can do, which is called a request for information. That's also contractually stipulated. So, so we can still get those same documents. It's just a different process. So that weakness, I think, is pretty well mitigated. And then, as we are making those requests, that also, if the agency, again, we can't control the actions of others. If they are choosing not to reply to those RFIs, the request for information, we can just fold that into the grievance and present that to the arbitrator also. So some pretty good reasons why we like the grievance process. It's much faster. We can get it in front of an arbitrator, and it uses the same laws and protections as are under the EEO procedures. So that's kind of a brief overview and a compare and contrast between the grievance versus EEO.